Everybody's ready. Well, could you read the usual form of words, please?
Yes, of course.
Thank you very much.
Good morning again, everyone. This hearing is the matter of case numbers ENF 022-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Al-Tamimi and Company. Lead counsel is Mr. Carl Anderson. The defendants are represented by Charles Russell Speechless, and the lead counsel is Mr. Stephen Doherty. Thank you, Justice.
Thank you very much.
Your Honour, good morning. I appear on behalf of the, the claimant and the applicant, GTC Trading, in this matter. My learned friend, Mr. Doherty, appears on behalf of the first respondent, Mr. Rashed. As we understand, the second respondent, HMR Investment Holding Limited, isn't legally represented in these proceedings and is not, as we understand, present today. Albeit you will have seen it is a wholly owned company, wholly owned by Mr. Rashed, and also Mr. Rashed is one of its two directors as well. Your Honour, this is the first hearing of GTC's committal application, and you may have seen from the skeleton arguments filed in advance of the hearing that to some extent the proverbial ships have passed in the night. And in particular, you will hopefully recall that on the 9th of November, Mr. Rashed filed an application for an order that this hearing be vacated with directions to be given for the exchange of evidence. Or alternatively, that this hearing be treated as a case management hearing pursuant to Rule 52.18 and 52.19. And Your Honour dismissed that application on the 14th of November. And I don't know whether it might be worth turning up your order that you made upon that application, which is at bundle N. Bundle Q, tab 7.
Yes.
And then if you turn to page 2220, your schedule of reasons, you stated in paragraph 3 that no sufficient basis had been advanced to the court by Mr. Rashed as to why the committal application should not currently go ahead. So in those circumstances, the registry's directions as to the exchange of evidence, and in particular Mr. Rashed's right to file evidence by 16th of November, still stood. But in the event the defendants didn't comply with that direction and no evidence has been filed in response to the committal application, we therefore proceeded to prepare a skeleton dealing with the substance of the committal application in the absence of any evidence in response. But to our surprise, Mr. Rashed then filed a skeleton argument which states expressly that Mr. Rashed maintains the position set out in his case management application dated 9th of November 2023, which you've already dismissed, and it advances no new arguments beyond the ones that have already been dismissed by you on paper. So in other words, you're unfortunately in a rather unsatisfactory position today, in that Mr. Rashed appears to be attempting to relitigate an application which you've already considered and dismissed. And in addition, he is elected to file no evidence at all in response to the committal application, and is now out of time for doing so. So on that basis, the first question for you today is whether or not this hearing should be treated as a case management hearing or as the substantive hearing of the committal application. And our position is that the committal application should be heard and determined and decided today. In essence, there is no defence to it. There are no case management reasons in favour of a stay, and Your Honour has already considered and dismissed the same arguments that Mr. Rashed now seeks to advance in the context of this hearing. So if it's convenient for Your Honour, what I would propose is that I address that question only for now, and invite Mr. Doherty to make his submissions on that point and ask you to rule on it before I say anything about the substance of the committal application itself.
Well, I think it'd be easiest if I hear from Mr. Doherty first.
Well, I'm very, very happy, given that it's essentially his application to move. I'm happy with that approach as well, Your Honour.
Yes, very good. All right, thank you. Mr. Doherty.
Yes, Your Honour. You, of course, have my skeleton. You see the reasons we resist the committal application. In effect, it's correct. The submission concerns a question of sequencing or case management of the committal applications. We don't accept that all of those issues have been vented before the court. Really, there are two components built into that. First, we've got what you might view as the general procedural considerations. Some of those have been laid before Your Honour already. The core point around that really is we say it's ballast, if nothing else, to the main substantive point, which is the second issue, which I'd hope to address Your Honour on today, which is the substantive legal point that arises from the Court of Appeal's recent decision in Sandra Holding.
Well, how does that really help you at this stage? I mean, I can understand that if at the end of the day everything is set aside, all well and good. But what's your defence to the fact you haven't obeyed a court order?
Well, Your Honour, I don't have the full instructions of what my client says in response to that. I can give you what the position is, which is...
Go on, give me what your instructions
the
are.
evidence that really was the core of why we've said that this hearing needs to be given over to a case management hearing in any event. And amongst those considerations that Your Honour would take into account, what we say is a full committal application hearing which should take place after the underlying issues have been dealt with. But amongst other things, as I'm sure my learned friend will come on to address you on, you'll be taking into consideration questions of when orders first came to the first defendant's attention, and Your Honour will be aware that there's a dispute about some of those issues around personal service and so on. That's not an issue that we say we're seeking a resolution on today. My client's position is that we aren't yet in the position to advance all of the evidence that we would want to on that point. His strong conviction is that the documents were not personally served on him, and that's a matter of recollection. It's not always or invariably the case that this is one person's word against another, one person is lying. It may well be those sorts of cases where one person thinks one thing has happened and one person is mistaken. And as I say, Your Honour, investigations about that are ongoing. At the beginning of this week, as I understand it, a visitor logbook was obtained for the building that service was affected in, suggesting that Mr. Paciso's visit to the building lasted a total of 3 minutes. Now, there are obviously going to have to be issues that are continuing to be looked at on that. So we've got the timestamps. I understand inquiries are being made and are ongoing to review the CCTV on those dates if it's still available. But the short point is that we don't have it yet. The second isn't solely around this.
When do you say that you first became aware of the terms of the orders?
Well, as I understand it, the position of the first defendant is that although it wasn't personally served, the documents were received it was just shortly prior to his committal to prison. And again, Your Honour, we say that that's something that would be picked up in evidence in response to the application in due course. So there's a question, of course, of if service is affected, what did the first defendant understand of it? And there's a number of factors to that. There's, as I say, the fact that he was committed to prison almost immediately thereafter and had to deal with issues concerning that. There are issues surrounding who, at that point in time, the first defendant's legal advisors were and what they properly understood of the order. Your Honour will no doubt also be cognizant of some of the issues we've raised concerning the language in which the first defendant communicates. He's an Arabic speaker, he's not an English speaker. That creates its own issues. We have allied to that his health issues, his laryngeal cancer, which means that actually, for the most part, he can't communicate, at least not for protracted periods at times. And all of that we say is relevant on my learned friend's application to proving to a criminal standard whether and when the first defendant knew the terms said to be breached and knew the facts establishing that it would have been a breach. And those are questions that are relevant to both, I suppose, a finding of contempt and sanction. And there's some other points, Your Honour, I have proposed to address you on in my substantive submissions concerning the form of the order that the claimant is now seeking. For example, the first we've heard in my learned friend's skeleton argument is that we're now seeking an application for a fine. There's been no opportunity to provide evidence on things like mitigation, what the level of the fine should be, and so on. That's something, with the greatest respect, which has been introduced by junior counsel in a skeleton argument, which, as much as I might wish sometimes we could do that, it should have appeared on the application notice. So there are issues which have been raised latterly, which there hasn't been any opportunity to provide a response to. The third point, dealing with this question of evidence and what it would include, there is, of course, also the fact that the first defendant's engagement of my instructing solicitors is a relatively recent development. And at the time that happened, I don't think any of the parties had contemplated or understood that a committal application was going to be processed, because the first thing the parties were concerned with at that stage was complying with the registry's direction to sort out the procedural issues so that we could get on a substantive hearing. And that's precisely what the parties did when they agreed a set of directions, which, as I say, didn't contemplate that this sort of hearing would be taking place before the substantive hearing. And the fourth point, and like I say, Your Honour, I'll come back to, and I'm happy to address you on all of my substantive submissions at the outset if you think it's the easiest way to deal with this hearing. But we say that there are...
I'm not very interested in the question of that has to be determined about the enforcement notice. You know, that's a separate question. That's not for today. The real issue is, on the face of it, your client has failed to observe the terms of disclosure orders. He's been aware of that for a minimum of 3 weeks. In practice, the argument only goes back to whether or not he picked up documents or was given them properly served back in February. But on any view, he's been aware of this contempt application for 3 weeks and been represented, and has chosen to put no evidence in, but has just done all he can to put off the evil day. Now, the question I ask is, what defence can there possibly be in relation to an order to give disclosure that has not been observed? And I've not been told of the defence at all yet.
Well, the final point I was going to raise, and which I propose to go through in some detail, there are at least legitimate questions surrounding the effect of Sandra Holding and what it means for the making of an order of contempt and the sequencing of that sort of an order.
No, there is, Mr. Doherty. The fact that the Court of Appeal in one sentence dismissed dealt with the contempt application and the sanctions and so on because they'd set aside the original order. That's neither here nor there as to whether or not there is contempt. I take the point about the sanction that's to be adopted, and there may well be a case for a finding of contempt, which seems to me to be one to which there's no defence today, and the question of what would be an appropriate sanction in light of whatever then takes place in relation to the enforcement notice and your application to set it aside. And speaking quite frankly, what I wondered about was simply making a declaration today of that your client is in contempt and leaving over the sanctions issue until I've determined the question of the validity of the enforcement notice and so on.
Yes, Your Honour, I take your point. I think the short answer is that I don't have a full set of instructions on what the defence to...
Why? Well, the question then is why. The question then, Mr. Doherty, is why not?
And Your Honour, the reasons for that are what have been articulated in terms of preparation time, in which, like I say, I'm happy to come on and deal with and the full thrust of our submissions also dealing with what the case law has to say about preparation for these sorts of application. I mean, one example is the Navigator Equities case that my learned friend relies upon, paragraph 11 in his skeleton.
I understand all of that, Mr. Doherty. I'm, sympathetic where there are potential defences to be run. But you come before this court today and you can't tell me what the defence is. And I can't see a defence when a court has made an order for disclosure, whether that court is right in doing so in the first place, whether it has jurisdiction to do so in the first place, is neither here nor there. Your client has an obligation to obey. And that's the beginning and end of it, isn't it?
Yes, Your Honour. I suppose we maintain the primary point. My client's position is that he hasn't had sufficient time to be able to prepare evidence in response. Your Honour has that point. I think that the second issue that we're really seeking to address is a question of how do we sequence the rest of it. So if Your Honour takes the view that there is contempt, what my client would still say is that he's entitled to put in evidence which is relevant to sanction, particularly where, as I say, this question of fine has only been raised in the skeleton argument, not in the application notice itself. There are a number of issues that we have with the form of order as well, particularly concerning, I think it's paragraph 3 of what's being proposed, as well as the proposal that has also been made in the skeleton argument only, but not in the application notice, that one of the effects of a declaration of contempt should be that Your Honour shouldn't hear from the first defendant when it comes to the substantive applications. And we do say that Sandra Holdings has something to say about that, as do, in fact, the English cases insofar as they're relevant. So if that was a course that Your Honour was proposing, I would have submissions to make on it. Really, one of the issues that we are seeking to avoid is the potential for additional procedural complexities to arise. For example, the need to raise an appeal protectively pending the outcome of the substantive hearings, because Sandra Holdings, of course, could have an effect on a contempt order subsequently falling away, which we would need to appeal if that was ultimately going to end up to be the case, or there's at least one view in which we would need to do that. And what the first defendant doesn't want is, in the intervening 3 weeks before we get these substantive applications on, for there to be more litigating, more costs, more distractions, when the court's focus, we say, should be on the set-aside applications. After those have been disposed with, a lot of these issues will fall away one way or another, because either the first defendant will be right, in which case the proceedings will fall away, or the claimant will be right, in which case it can maintain all the points that it wants to maintain today in respect of committal.
As I understand it, Mr. Doherty, there's only really one point in relation to the setting aside of the enforcement order and the worldwide freezing injunction and final charging order, and that's the meaning of AMVAL. Is that right?
Yes, I suppose putting it in slightly different terms, it's about the scope of what the DIFC court is enforcing on, and how that interacts with the onshore position, and what that means for the court's jurisdiction. That's really what the issue is about. Well,
doesn't it resolve simply around whether AMVAL means assets on the one hand or money on the other? Matter I've come across, I'm bound to say, as a matter of Iranian law, but that's a different question.
Well, it's interesting to know that Your Honour is aware of provisions of Iranian law, given the factual background to this dispute.
Yes, well, there we are. But that's the issue.
In a nutshell, there are subsequent communications from the Dubai courts, which we say sheds light on that and so on. But yes, in a nutshell, that's what the substantive hearing is going to.
Yeah. Well, I haven't looked in any detail at the exchanges since. But in any event, that's a matter for another day. It's not a matter for today. Yes, all right. Well, I have your submissions, I think.
If I may, Your Honour, suggest this, I mean, it may well be worth broaching. As I understand it, what you're proposing, in effect, is that you're going to make the declaration only as to a finding of contempt, with the consequences effectively held over until after the substantive hearing. I probably do have a point to make about paragraph 3, but what I would suggest maybe an appropriate course is to ask for the claimant's view on that, and to see whether it's sensible for both of us to go take instructions from our client on what you're proposing and whether or not that's a shortcut.
Well, that is what I'm proposing. The reason is perfectly obvious, Mr. Doherty. This is not a case where I was thinking of shutting your client out from arguing on his point on the enforcement notice. The reasons in Sandra Holding, if you're interested, is that there'd been a complete failure to in any way grapple with what the court was doing for an enormous period of time. And then at a very late stage, they wanted to take some points about the form of the order. And I said, well, I can see the jurisdiction point. We have to deal with that. But if I'm against you on jurisdiction, it doesn't seem to me right that until you've purged your contempt, you can come back before the court. Now, there's plenty of authority in England which say you've got to give even a supposed contempt not a fair chance. And I fully take that point on board. And I'm not going to shut your client out. But on the face of it, in circumstances where I can see no potential defence to the contempt in failing to obey the court order in giving disclosure, and where plainly that's a relevant factor in the context of enforcement, the contempt is plain. Your client, on the face of it, has had plenty of time to tell the court what its defence would be and to give you instructions as to what the defence is, and has not taken that opportunity. It seems to me that a declaration of contempt must inevitably follow, but sanctions should be left over in order to see whether or not, in fact, the order about which he is in contempt should or should not be set aside. So that's what I have in mind.
Yes, Your Honour, that's well understood. I suspect I would need to take instructions from my solicitors on that. I suspect that my learned friend might be in a similar position. So I don't know whether...
Well, I don't know why you should take instructions, because it's a matter for me, isn't it?
Well, it should take instructions on whether we have anything further to say, is what I mean.
All right.
Because it may well be that there are further points that we had to say. And in particular, in Sandra Holdings, I spent quite a considerable bunch of time reviewing the footage to go back to the arguments that were raised there. And we have a number of points to make. But I think that the two things that we would need to understand is, one, whether I'm going to say anything else to you, Your Honour, and two, whether my learned friend is planning to seek anything further than what you're proposing.
Well,
that we would need to respond to.
Let me hear from Mr. Anderson, and then if both parties wish to take further instructions, they can. But as I say, at present, that seems to me the right course to adopt, which would give your client not only a chance to argue that the enforcement notice is invalid, but if they have points to make on appropriate function and want to put in evidence about their financial position and that sort of thing, that's a matter for them. I mean, in the ordinary way, it is not for a claimant to tell the court what sanction it ought to adopt in any event. A claimant is entitled to point to the level of sanction that has been adopted in other cases. Every case is different. But at the end of the day, what the claimant here wants to do is to enforce against the properties concerned. That seems to be the key to it. That's the one thing they do know. But they also need to know what other assets there might be to enforce against if the enforcement order is valid, which is why your client's failure to obey the orders is particularly worthy of condemnation. Anyway, let me hear from Mr. Anderson.
Your Honour, I'm very grateful for that indication. I have had the chance to take some interim instructions on our position in relation to your proposal, and my instructions are that we would press for at least some sanctions to be imposed today, on the basis principally that the first defendant has had a significant amount of advance notice of this application, and a significant opportunity to put in any evidence in response to it, and has simply declined to do so. And indeed, my learned friend can't give you an answer to the application on instructions because, as Your Honour has pointed out, there is no response to it. It might just be worth me very briefly taking you through the timeline of just how much notice the first defendant has had of these allegations of contempt, if that would be helpful. Looking at sort of two aspects of it. The first is this, that notwithstanding what the first defendant says about his ability to prepare to respond to this application and put in evidence, he has engaged substantively with these proceedings at almost every stage since the making of the orders on the return date. But notwithstanding that, he's made no attempt to comply with the information order. He has, as you've seen, filed applications to set aside the enforcement order, the charging orders, the freezing order. His legal representatives have written countless letters to the registry seeking to litigate this matter in correspondence. And indeed, he filed the application to vacate this hearing. So he's well able to engage with these proceedings where it suits him, but has simply elected not to do so on a point to which he has no defence and no answer. Now, the most important aspect of that point is the fact that the first defendant has filed a 7-page witness statement, which he did on the 8th of November, in response to Mr. Bessisso's third affidavit. But his evidence only responds to the third affidavit insofar as it relates to the first defendant's set-aside applications. And he's deliberately avoided responding to the brief section of Bessisso 3, which deals with the committal application. And you can see that at the outset of his witness statement. It's at bundle N, tab 12. I might invite Your Honour just to look at that briefly, because we do say it is telling and evidences the first defendant's attitude to this litigation and the contempt and the informal phrase that he seems to have for the orders of this court.
Yes, which part do you want me to look at particularly?
It's paragraph 3, Your Honour, the first page of his witness statement, where
yes.
He says, I make this statement in response to the third affidavit of Karim Bessisso, dated 25th of October, insofar as it relates to my application to set aside the enforcement order, etc. And then at paragraph 6, he goes on to state that the committal application was not served on me until shortly before the deadline that had been agreed between the parties for filing this witness statement. So I'm not in a position to respond to the points raised at that time. But the absurdity of that position is that the committal application included Mr. Bessisso's third affidavit, which he has responded to in the remainder of his witness statement insofar as that affidavit related to his applications. So in other words, he had exactly the same amount of time to respond to the points on contempt as he did the points on his set-aside application, but simply elected not to. So that's the first point. The second point is that, as you will have seen in Mr. Bessisso's third affidavit itself, there has been extensive warning in correspondence as to the claimant's right and intention to bring an application for committal. Now, Your Honour, unless it would assist, I don't intend to take you through each and every one of those letters, but suffice it to say that we have written every time the first defendant has changed legal representatives in these proceedings, beginning with in April of this year, pointing out that the first defendant is in contempt of court for having failed to comply with the information orders. And at no stage has he offered a response to that. And again, we say that because there is no response. And it was simply fortuitous. The Court of Appeal's decision in Sandra Holding was handed down in September of this year, and he has used that as a lifeline on which to try and avoid any sanctions in response to his contempt. So I make those points in response to what my learned friend said as to the first defendant's ability to prepare this application, and in particular on the question of whether or not he has had a fair opportunity to consider the proposed sanctions as well. Now, in relation to that point, my learned friend said, well, there are a number of points that have been raised in the skeleton that haven't been raised in the application notice or the evidence. And there are 2 points in response to that. The requirement with regards to the content of the application notice under RDC 52 relates to the particulars of contempt. And the rule is that an applicant cannot go outside the boundaries of those particulars of contempt that are included in the application notice, because obviously it wouldn't be fair to the contemnor to deal with those points, having not had advance notice of them. But the question of what orders the court should make upon a finding of contempt is a different one. It's not one that requires every single order to be included in the application notice. And indeed, as Your Honour has pointed out, it is principally a matter for the court as to what order it decides to make. And the most that the applicant can do is point out what orders it considers would be appropriate in the circumstances.
Well, it's not even meant to do that.
Well,
the claimant is only meant to inform the court as
yes.
to its options and as to the general standards that the court adopts. But it's not, as with a criminal complaint, it's not for the prosecutor to tell the court what the appropriate sentence is.
Indeed, I wouldn't argue against that, Your Honour. And indeed, in our skeleton argument, we did in some places try to couch the language in terms of the fact that the court may consider these points to be
yes, understood. Understood.
But there are, in my submission, there are clear reasons to consider the question of sanction today, and they principally relate to the fact that this contempt has been in place, or rather the defendants have been in contempt of court for now a period of nearly 8 months. And the claimant's position is that the fact that no defence has been offered and the length of time of which the contempt has been in place, and the complete failure to make any offers to purge the contempt, are all factors which warrant a particularly strong response from this court to indicate to the defendant that it is simply not acceptable to ignore and flout these orders on the hope that at some point in the future those orders might be set aside. That is simply not an acceptable way of conducting litigation in this court, and it warrants, in my submission, immediate and forthright sanction from the court in this hearing. Now, as to the sort of case management question as to, well, what happens if in 3 weeks' time the enforcement order is set aside, at that stage, obviously, any sanctions that are made at this hearing can be overturned if the court agrees that the effect of Sandra holding is that those contempts are essentially null and void. Now, obviously, we don't accept that is the position. But there are benefits to the court making those sanctions in the interim, even if it has to consider on a sanction by sanction basis what would remain effective, what would remain an effective sanction in that time period. And in particular, what we're thinking about in those circumstances is not necessarily the imposition of a fine or a reference to the Attorney General, but in particular, the order that, and the declaration that the judgment must be complied with, which is the paragraph 3 of our draft order, and the question of whether or not the defendant should be heard at that hearing until and unless his contempt is purged. And we say that's a very important point, and this is an opportunity for this court to mark its strong disapproval of the applicant's, what we say, egregious contempt of this court's orders, by making an order that the defendant shouldn't be heard at the subsequent hearing until their contempt is purged. And the principal reason that we say that that would be an order worth making in the interim is that it might actually encourage the defendants to comply with their obligations under this court's orders. And in particular, the court will know that it's essentially a balancing exercise and considering all the factors in the interest of justice as to whether or not to make such an order. In my submission, it would be very easy for the first defendant to comply with these information orders. The time limit that is put in place for information as to assets to be disclosed under freezing orders is very short in the first instance in any event. It's normally a matter of days, following which it then has to be confirmed by sworn affidavit. And that's in circumstances where the freezing order shows up on the respondent's doorstep after the ex parte hearing. In contrast to that position, the first defendant has now been on notice of the terms of this order since at least March, but we say February of this year. So it would be very, very easy for him, we say, to comply with those information orders pending the resolution of the set-aside application in December. So there's very little prejudice to him. He can very easily purge his contempt. But on the other hand, in relation to the claimant's position, the fact that the first defendant has failed to comply with the information orders is, we say, thwarting the very purpose for which these proceedings have been brought, which is to enforce the onshore judgment. And unless and until we know what other assets the first defendant has against which we can enforce, these proceedings are, in other words, being thwarted. And the only asset that we have been able to identify after painstaking efforts onshore to locate these buildings, which we say were transferred in order to frustrate the judgment debt. The first defendant is now taking steps of enforcing against those anyway, rather than simply paying the judgment debt. So in those circumstances, and again, bear in mind that it's not the claimant's position to recommend sanctions to the court, we would say that there are tangible benefits, at least to certain orders being made in the interim, even if they are potentially set aside later, for those two reasons I gave. First, to mark the court's disapproval of the contempt, and secondly, because they can have real and tangible benefits not only to the claimant in terms of its pursuit of its claim, but also to the conduct of this litigation as a whole. So, Your Honour, that I think is what I would say in relation to the question of whether or not any sanction should be imposed at this stage.
But one has to think what the effectiveness of such sanctions would be. I'm not in an English court where I can commit the defendant to prison to give him a chance to think about whether he wishes to purge his contempt or not, and imposing a fine, which is basically the only other option. One wonders how efficacious that is going to be in the circumstances. He's ignored every other order of the court. Why is he likely to do anything in relation to the imposition of a fine? That's one of the problems of the system in the DIFC, is that one doesn't have the powers of a judge in the UK.
Yeah. Yes, and Your Honour, that's why I sort of say that it may be that if the court is with me and at least considering that some orders ought to be made, it should consider which of those ought to be effective. Now, it's an unfortunate position to be in, to say that no orders should be made because there is no chance of compliance with them. Unfortunately, that is quite a perverse situation to be in, through no fault of the court. But as I say, it may be that in particular an order that the first defendant can't be heard until his contempt is purged is applicable. And in addition, I mentioned our order that, or the paragraph in the draft order that deals with the fact that the first defendant shall comply with the enforcement order and satisfy the judgment debt within 7 days of the date of this order on further penalty of contempt.
But that's the current position anyway. He's already being ordered to pay because the judgment's been recognised. Yes.
Now the reason we have included that provision in particular is because under the relevant rules of the DIFC court, there is a requirement that in order to pursue a writ of sequestration for a contempt, the order for payment of the judgment debt has to include a time limit for payment. And as matters currently stand, our enforcement order doesn't include such a such time limit. So the reason we've included that is simply because it then gives the claimant the option of pursuing a writ of sequestration in the future, to the extent that the first defendant still refuses to purge his contempt. So that is the thinking behind that order. in those circumstances, it's not any sort of imposition on the defendants to make that order pending the outcome of their set-aside applications.
Yeah.
I think that's all I intended to say, unless I can assist you any further on that particular point. That was all I intended to say on the question of sanction.
Yes, thank you. Mr. Doherty, have you had a chance to think further?
Yes, Your Honour. I suppose what I would first ask is whether you wish to hear from me in response to sanction, whether you're minded from your original position of making a declaration only with sanction to be addressed later. Obviously, the extent to which I'll address you on that will be depending on what your view is.
Well, I'm certainly thinking of making a declaration of contempt. I'm also considering the question as to whether you should be given an express period of time in which to purge your contempt by producing the relevant affidavit of assets, and whether there might be a sanction that if you don't purge your contempt in that time, certain consequences would follow in relation to the hearing as to the enforcement notice. So you may want to address me on that.
Yes, certainly, Your Honour. In that case, I think the important place to come back to is the Sandra Holdings decision. It's obviously generated quite a lot of commentary and quite a lot of stir in the jurisdiction. Maybe that's
Yes.
for good reason, but it is a unanimous decision of the Court of Appeal. It stands as DIFC law. And one of the things that I think my learned friend tries to get across in his skeleton argument is that, well, Sandra, you ought to limit to its own facts. I think it's suggested that the decision was per incurium, so made without regard to the law or facts. Is it almost as if the point was taken and produced in a single paragraph in isolation without having actually heard anything about it? And there are two problems with that sort of a submission. And the first, which I think will probably not be lost on Your Honour, is that the underlying factual background in Sandra is not entirely dissimilar to where we find ourselves in the present case.
It's very dissimilar in terms of having a judgment against you.
I suppose what I mean is an application to set aside a worldwide freezing order some months after it's granted. And in fact, I think in Sandra, the committal application preceded even the making of the set-aside application. So there are points that one can compare, and similarly, different questions of jurisdiction, but there are questions ultimately which go to the court's jurisdiction in both. The second...
They don't go to the court's jurisdiction in the same way, do they?
They don't go to this court's jurisdiction in the same way, but they do...
If you adopt the Court of Appeal's approach of talking of prima facie jurisdiction and ordinary jurisdiction, there's no question of prima facie jurisdiction under the relevant enforcement provisions. Here, the only question is what the terms are of the execution that has been requested.
Yes, although we say that scope, I think this is an argument for another day, but if effectively what we say is that question of scoping does go to the question of jurisdiction, because the way that Article 24 of the court law works is that the court assumes a jurisdiction once the preconditions set out in JAL are established. And so we say that to get into enforcement under the court law, you need to go through the steps in JAL in the same way as if it was an Article 5A1 case. You need to have an enforcement letter, you need to have it setting the terms that it's complied with, and so on. So unless you comply with those preconditions, the court's jurisdiction never crystallizes. As I say, I don't think that's necessarily a point for today. I suppose the broader point is we say it's a jurisdictional issue, as in Sandra.
Yeah.
The second point about what my learned friend says in his skeleton is that
I could certainly impose a condition that unless you purge the contempt within 7 days, you shouldn't address the court on sanctions. What would you say about that?
Well, I'd say we would resist it first of all. If it's, I suppose in some ways it doesn't matter, because the way, as I understand it, the order is going to be framed is we're going to end up dealing with the question of sanction after we deal with the substantive applications anyway, whereby the question of the court's jurisdiction is by that time going to be established, and that will probably
I have that in mind. I have that in mind because it's self-evident, whatever the logic of the position, that the court's attitude to an appropriate sanction will be impacted by whether or not it was entitled to make the order in the first place.
Yes.
That's just being realistic about it.
Yes, and I think that comes back to where we've identified at the outset of the hearing the problem arises as one of sequencing, potentially more than a question of the court's powers. I suppose the point I was going to make is that...
Let me just tell you this. It's obvious, Mr. Doherty, but my problem is this. The court's orders are made to be obeyed, and whether they're rightly obeyed or wrongly made, they have to be obeyed. And that's a message that has to come across loud and clear, and which in the UK courts would come across loud and clear with a short sentence of imprisonment to ensure that the person concerned had got the message. Now, there's a problem here that I can't imprison anybody. It has to go through a long process of reference to the Attorney General and so on and so forth. So I can't have a short, sharp shock to make someone stop and think, yes, I ought to obey the court order. But I am very keen that this order should be obeyed for obvious reasons, and very keen to mark the point for the future and to put the Court of Appeal's decision in relation to the contempt side of it into context. I don't for a moment believe that the Court of Appeal really had the chance to consider the matter properly, would have decided that because an order is set aside, there's no reason for it to be obeyed in the interim, and it wasn't contempt. That's not. They were just getting rid of the whole thing in a short sentence at the end of the day, in circumstances where the claim was on its face difficult because it hadn't succeeded in any jurisdiction thus far. And they decided there was a jurisdictional point that meant that it wasn't open to the court to make a freezing injunction in favour of foreign proceedings, leaving aside the apparent anomaly that you can do it in relation to arbitration proceedings. Anyway, there it is.
Your Honour, yes. Really, that was the point I was going to focus on, this idea that it was per incuriam, is that it's not actually quite... That's not quite the situation we're in. My learned friend's submission assumes that the decision of the Court of Appeal was made in isolation and without the benefit of oral argument or proper consideration of
I don't know
the points your Honour is raising. And as English practitioners, one can have every sympathy for the view you've expressed. And really the points I'm going to take you to in Sandra Holdings underscore the differences between the jurisdictions, and whilst it might well be lamentable in terms of the court bearing its execution powers if they can throw someone in prison, the fact is the DIC can't, and that might well be one of the reasons why the effect and the position in Sandra Holdings has placed it in a different zone to where what was referred to in that case as sovereign courts or courts of unlimited jurisdiction would be. And perhaps if I can give Your Honour an illustration of these sorts of points. One of the citations in the learned friend's skeleton at paragraph 21.1 is the extract or the statement of general principle from Guillaume Injunctions. It's chapter 19, paragraph 4. It's at 2652 of the bundle, if Your Honour wishes to look at it.
2652.
Yes. And it's the first section on that page saying when the injunction commences.
Sorry, I'm not with you at present. Why is this not doing what it should?
I frequently ask that question of the system.
Yeah. Okay, I'm there now, yes.
So the point my learned friend says is this is, even post Sandra, what the position ought to be in the DIFC. An injunction takes effect the moment it's pronounced unless the court orders that it to take effect at a later date. It continues in effect until it's set aside. Breach of the order is a contempt, even if it's subsequently set aside. And I think my learned friend gives a number of further citations for what effectively is that statement. What he says is the rudimentary legal principle, which on the claimant's case applies as a matter of DIFC law. The problem there is that the precise statement we're referring to here from G, which is relied upon, was actually before the Court of Appeal in Sandra Holding. It's Your Honour, I've had the benefit of downloading what is a transcript of the YouTube hearing, which is not a completely accurate transcript, but I've been able to read it and I've gone back to the video and looked at it. What I'll do is, if Your Honour wants to go look at this at some point, but it's on day 2 of the hearing, 1 hour, 5 minutes and 50 seconds through to 1 hour, 13 minutes on the YouTube video hearing is where you'll find these arguments being made. But I'll summarise what was being discussed there in any event. The context of this discussion is the decision in Motorola and Uzan, which featured heavily during the hearing. It didn't feature quite so prominently in all aspects of the Court of Appeal's decision when it came to contempt, but it has got a couple of important points I'm going to circle back to. But amongst the points being made is there was a discussion as to why it was open to the court to refuse to hear from a party in contempt. There was a discussion of the fact that non-compliance with the worldwide freezing order was one of these cases where such an order should be made because you're impeding justice by depriving the respondents on the appeal from information concerning assets that they were seeking to enforce against. And there were also arguments that it amounted to an abusive process and so on. And then there's also discussion of the circumstances which a party, even if it turns out the order shouldn't have been made, must still abide by it. And if they don't, they're in contempt. So some of the issues that we're considering here. And that's where we find in that discussion citations of the PwC case, PwC and SAD case, which it was referred to by the Court of Appeal when it made these findings. And we hear very similar submissions being made concerning the policy that lies behind the principle, which is that it would not be workable if parties are free to act as though an order was not binding upon them. And it's at that point that counsel for the respondent, it was Mr. Bohr, came to read out the exact principle that my learned friend cites in his skeleton from G. And again, if you want to go listen to that, it's at 1 hour, 12 minutes and 4 seconds. And in fact, he goes further than that to quote another extract from G, which, Your Honour, I've added to the bundle so you can see it, but it's at 2836.
Sorry, page again.
2836.
Thank you.
And John will probably note that in doing this, what I'm doing is bringing you to arguments which on their face undermine the position that I'm setting out. But there's a good reason that I'm doing that. So you can see here, and this is me reading from what was said in Sandra. This is Mr. Bohr for the respondents to the appeal. He says, G says no one can justify contempt on grounds that the order should never have been made or was irregular. And if an order has been made, it must be obeyed until it's set aside. Whether the original order should have been made may be irrelevant to an appeal challenging a committal order, breach of the order.
Yeah.
So the point there really is that the court in Sandra was aware entirely of the thrust of the submission that the claimant is now making, and in fact it was taken to precisely the same extracts and the same authorities.
Right.
And in fact, if I'll give you another reference, Your Honour, this is day 1 in the Sandra case at 3 hours 15:20 to 3 hours 17:10. And this is an extract where Mr. Bohr is making submissions on the court's policy considerations as part of his introduction. What he says is, to win on the appeal in relation to the set-aside application, what the defendants will need to show is that the DIFC court has no jurisdiction over the defendants who fail to contest jurisdiction, who have assets in Dubai, and we say possibly in the DIFC, who is subject to international claims involving serious wrongdoing, and we say this would be completely contrary to the authorities and the policy issues which underpin them. To win on the appeal in relation to contempt, the defendants will need to show that there would be no sanction imposed on a party who completely ignores a WFO, who fails to apologise, who fails to purge their contempt, and acts disgracefully in other ways, which I'll come to in a moment. And we say this would be contrary to every authority. The authorities are quite clear that once an order has been made, it needs to be obeyed. And similarly, a win for the defendants will undermine the reputation of the DIFC court as an international court and encourage unscrupulous parties to ignore orders from the court.
Yes.
And again, it can't be said that the Court of Appeal were going into this decision that they ultimately made in paragraph 111 in the dark. In fact, what we find Mr. Bohr saying in his oral submissions is pretty much a mirror image of the submission the learned friend just made. And the point is that all of this material and argument was actually before the Court of Appeal. It heard submissions that an order must be complied until set aside. It heard that there would be contempt even if the order was subsequently set aside. It heard that it would still be contempt even if the order shouldn't have been made in the first place, not only that it's set aside. And it heard submissions on all of the policy reasons why the court should reject the appeal, but it didn't, having heard all of those arguments.
It didn't give any reason.
Well, it didn't, but it had the argument, and I really, the point is that this isn't something that was not thought about. It may well be that the reasons given in the judgment are not detailed, but the arguments were there. And
Going to be wholly unpersuaded by that without reasoning from the Court of Appeal. I certainly will not regard myself as being in any way bound by the conclusions in paragraph 111 and 112. So I tell you that at the outset.
Yes, and
whenever we get to the sanctions issue.
Yes, and I understand that, Your Honour. The point that I then come to is the other arguments that were also before the Court of Appeal, and this is the Motorola case, and this centres in on this question of sanction and not hearing from a party. But in the extract of day 2 that I'd referred you to, there was a lengthy discussion of that case and the 3 points that the respondents were relying upon. That's a 2753.
Well, Miss Doherty, there have always been two, I won't say different lines for authority, but two different views as to how you approach this matter of do you hear from a party or not hear from a party. And the authorities don't speak with one voice, do they?
Again, without delving into it, there was a discussion of that point as well in Sandra Holdings and whether there was a conflict in the authorities or not. I suppose the central point is, well, I can take you to, if you go to 2767 in the Motorola case, because this refers to Arab Monetary Fund, which is what my learned friend relies upon.
Are you going to be suggesting to me that there is no scope for the court to say they're not going to hear from a party unless the contempt is purged? Is that your submission?
My submission is that it is rare for a court to make that order when the hearing in contemplation is, when you come to dealing with, are we going to set aside the underlying order that you're in contempt of. And the submission that I'm going to make is to say that in similar factual circumstances in Sandra Holdings, the court decided that they should hear from the party seeking to set aside, and that in this case we don't meet the threshold for excluding that argument. So when it comes to the sanction that my learned friend is asking for, the court should not impose that sort of a sanction in this case, and that would be inconsistent with how the Court of Appeal approached it in Sandra.
The Court of Appeal in Sandra appeared to miss the clear distinction that I drew between the ability of a party who was in contempt to come along and say there was no jurisdiction to make the order at all, what they would call the prima facie jurisdiction point, which I obviously was prepared to listen to and decided against the contemnor, but the Court of Appeal decided otherwise, and not being prepared to hear the contemnor on the issues as to whether or not the injunction should have been granted if there was jurisdiction to do so. And that appeared to me an entirely logical distinction to draw, but the Court of Appeal simply doesn't grapple with that at all.
Yes.
And that's the sort of distinction that I have in mind in the present case. And the difficulty may be to characterize exactly the nature of your complaint. And that's why I discussed with you earlier whether it was really a complaint that goes to jurisdiction, prima facie jurisdiction, or whether it's simply an argument as to why the court shouldn't exercise its jurisdiction in a particular way based on the wording of the letter of request. Now, that may or may not be important, but you can see the basis for a distinction as to what one might be prepared to hear a party on and what one might not be prepared to hear a party on in the context of an unpurged contempt. So I really would like to know exactly what your submission is to what the court's approach ought to be.
Yes, Your Honour. I think that the first point is to say that we consider that this is effectively a jurisdictional question which you ought to be hearing us on anyway, and you will hear the detail of those arguments. But I suppose my submission would be, even if that wasn't the case, even if we were dealing with circumstances where there were mixed questions of jurisdiction and other reasons, that the effect of Sandra Holding is that you should still proceed to hear from us anyway, because the orders that we're dealing with relate to how the contempt arises. So the contempt arises from breach of orders, which we say shouldn't have been made in the first place. And that comes from the Motorola case and also from the Arab Monetary Fund case, which were before the Court of Appeal in Sandra. It is paragraphs, so it's page 2767 is where the extracts start. And this is in the context of a submission by Mr. Bohr for the respondents. He says, I rely on Motorola for 3 points.
Yeah.
So the first chunk of extracts that were referred to in reliance on the first argument was 47 through to 51, where we get some of the statements of general principle. And Your Honour will obviously be able to read that, but 47 is this classic statement: the starting point to refuse to hear a party is a strong thing only to be justified by grave considerations of public policy.
Yeah.
Paragraph 48 deals with the principle arising from the Arab Monetary Fund case, which my learned friend referred to in his skeleton, where it says that it's wrong to use your starting point that the proposition is that the court won't hear from you if you're in contempt, but then to ask if the case falls within an exceptional category. So it's preferable to ask whether in the circumstances of an individual case, the interests of justice are best served by hearing a party in contempt or by refusing to do so, bearing in mind the paramount importance which the court must attach to prompt and unquestioning observance of court orders.
Is that the principle you invite me to accept?
I suppose the statements of broader principles, what we say is your starting point is that it's a strong thing to do. The circumstances in which you should refuse to hear from a party are an exception, not the norm. And that's what we would ask you to derive from the statements of general principle at 47 through to 51. And then it's 52, which was the second point being made by the respondent in Sandra Holdings, which is, well, when do you get into that exceptional category? There's reference to this Exxon Morgan Grampian case. And it says one, of course, can envisage circumstances in which the court would be unlikely to exercise its discretion in favour of hearing contemner, but I would not be in favour of laying down any rules for the exercise of the discretion, though it can do no harm to give examples. For instance, where the appeal was grounded in alleged lack of jurisdiction to make the order at all, would seem in general right that the commenter should be heard.
Yeah.
And sorry, I skipped out one of the central parts of that was referred to in Sandra Holdings, which is, well, where do you find the exceptions? It's in the middle part of that paragraph. In the case of an abusive process or of disobedience to the order impeding the course of justice. So it's a discretion. We are taking into consideration the policy issues, and what was said by the respondents in Sandra is, well, this is an abusive process because the parties didn't challenge the worldwide freezing order when it was made. They only did it 9 months later. And in any event, they say it's impeding justice because if you've got an order for the provision of information, you are impeding justice because you're not providing the information and thereby undermining the terms of the order. And the short point really is the Court of Appeal obviously heard that argument. It heard the policy arguments, and its conclusion is what it says in paragraph 108 of that decision. Sorry, bear with me, I'll get you the page reference.
Yeah, I've got it.
In which case I'll get myself the page reference. So bear with me, or I'm just waiting on the system to pull up the case. Yes, in 108, the appellants acknowledged they should have acted more promptly, but argued that just because the challenge to the worldwide freezing order was not made within the time frame does not make the original order issued valid. The appellants admit that failure to comply with the rules of the DIFC on timing of the application to challenge is outweighed by the injustice of being subject to an order that should not have been made in the first place. It refers to Lord Bingham and Arab Monetary Fund and the starting point that one takes there. And the court should consider what's the interest of justice required. It refers to Motorola decision, and it also points out that in the Motorola case, the Court of Appeal in Uzan found that there was strong evidence of fraud and that each of the appellants repeatedly flouted large numbers of court orders, and yet the appellants were still permitted to advance their submission, and having done so, the freezing injunction was overturned on the basis of an inadequate connection with England and Wales. These authorities support the submissions by the appellant on this point. So bringing that back to the question of whether or not there should be that sort of a sanction in this case, as I said at the outset, there are two bars we say to that. One is if my learned friend's position is that Sandra Holdings should stand on its facts. Well, when one actually looks at the procedural history and background and issues in Sandra Holdings, we're actually looking at quite a similar factual circumstance. And if the Court of Appeal said that you should hear from the parties in that case, then well, if one cross refers that you should hear to from the parties in this case on, whilst different, similar issues in nature. And the second point is the legal effect of the principles and what the DIFC court has said it should do when faced with circumstances like this. And we say that Sandra Holdings is a reasonably firm stamp that where you are dealing with questions like this, it should be in a pretty exceptional set of circumstances that you shut out a party. And we say that's particularly so where the question is one of, should the order have been made in the first place, rather than, for example, being set aside by some change in circumstances or something like that. And I suppose that's a quite circuitous way of saying that if Your Honour was minded to make an order, we would be back at an order in the terms in which Your Honour suggested at the outset, which is that the appropriate sequencing in my submission would be that if you're going to make an order declaring that there is contempt, that it should stop there, that there shouldn't be any further question of sanction, because, again, for the reasons I addressed you at the outset, those should be dealt with after the first defendant has been provided with an opportunity to provide evidence, amongst other things, on mitigation and the like. And that the reality is that there is very limited prejudice to the claimant in proceeding in that way. And I make a couple of points on that. The first is something which I think Your Honour has observed. Ultimately, what the claimant wants here is to take its order from the Dubai courts and to enforce it here by executing against the shares. And the way that that's going to happen is if in 3 weeks' time they succeed and the defendant fails in those jurisdictional arguments, what they'll be able to go is procure a sale of the shares, which I think its common ground exceeds the judgment debt quite considerably. So what's the fastest route to getting what it wants here? Probably it's that. Probably it's nothing to do with the committal applications at all. So you take that and you set it against and you weigh it against, well, what happens if you make an order which includes a host of sanctions now, including not actually hearing from the defendant at the set-aside applications. And what we say is that that leads to is satellite litigation, it leads to appeals, it leads to further litigating, which is going to slow things down, not speed it up, when the best course is to carve a pragmatic course through the post-Sandra landscape by making orders on sanction which post-date the decision on set-aside, where we'll know one way or the other whether these matters fall away or not. I think that's the broader submission that I have to make. I did want to address, Your Honour, on something slightly different, which is this paragraph 3 of the order, which relates to the enforcement order. And Your Honour will find it's a 2168.
Yeah.
So the 2168 is the draft order. If you go over to 2169, you see what is being requested, which is the first defendant shall comply with the enforcement order and satisfy the judgment debt within 7 days of this date on further penalty of contempt. Our position on that is we somewhat struggle to understand that order and the basis upon which it's made. There are a couple of reasons for that. The underlying order we're talking about, Your Honour, is the enforcement order. That's at 1241.
Yeah.
And we can see it's 3 short paragraphs. The application is granted to the operative part. The judgment is ratified, recognised and declared enforceable as a judgment of the DIFC court pursuant to the JAL. 3 costs reserved. What we say is that it's not entirely clear what is meant by the suggestion here that the defendant has not complied with this order, because what this order does is it ratifies the underlying Dubai judgment and says it can now be enforced in the DIFC. But of course, it's through that ratification that the claimant is then taking the enforcement steps in order to try and obtain payment. So that's through the charging order, and that's through the Part 8 claim, seeking an order for the sale of the HMR shares. So in terms of the idea of complying with this order, it doesn't say defendant to pay this amount, let alone to pay this amount in days. It has to be by reference to what the underlying judgment that's being enforced in the Dubai courts is. And of course, that is one of the issues which is going to be dealt with at the set-aside applications and on consideration of the Part 8 claim. So
it's simply a money judgment, isn't it?
Well, yes, but the question is, what is the scope of that order? Does it permit the sale of the shares and so on?
No, I understand that all goes to the letter of request, the 21st of January letter, whatever it is. But the actual judgment in onshore Dubai is a money judgment, which on the face of it, they're entitled to enforce in any way that is open to them in the DIFC. Isn't that right?
Yes, and that's what we say they're doing. That's what the purpose of the charging order is. That's what the purpose of the Part 8 is. What we say is that there's no basis for the type of order that is now sought for this payment within 7 days, because it's undercutting the normal processes of enforcement, which is the Part 8 claim and which is the charging order. And in any event, what the claimant seems to be doing is trying to take an order for payment that it is effectively trying to enforce through the Part 8 and attaching contempt proceedings to that. But of course, this enforcement order at 1241 doesn't have a penal notice in the way that a worldwide freezing order does. So we say it's not an order really that is open to Your Honour to make on this sort of committal application. So we say that even if there's a declaration of contempt that is the outcome of today, this paragraph of the order, paragraph 3, shouldn't be made, because effectively what it's trying to do is to short circuit the process which is already ongoing and taking place through the Part 8. I don't know if it would assist Your Honour at this point if I could take just a couple of minutes to check with my instructing solicitors if there's anything they want me to add to that.
I should have thought you've said everything that could be said, but you may have 2 minutes.
People often tell me that. Thank you. No, Your Honour, thank you for giving me that time.
All right, thank you. Mr. Anderson.
Your Honour, I'm grateful. I think I can be brief in response to the points raised. Famous last words, but I think I can cut through, starting with this Sandra Holding point. In my submission, I can cut through quite a lot of what my learned friend said about this. And in my submission, the reason I can cut through it is because what my learned friend hasn't done is distinguish between 2 stages of the analysis on this question of contempt and orders made without jurisdiction. The first stage, which is the latter stage in time, is what happens if a respondent is found in contempt of court and the order which gave rise to that contempt is subsequently set aside. Now, that is the question that the Court of Appeal's judgment in Sandra Holdings addresses, albeit very briefly in a single or a couple of paragraphs. So the question there is, in other words, once the order has been set aside, will the contempt still be a contempt, or does it follow that the contempt falls away as well? That's one stage of the analysis. The second, but prior stage of the analysis, and the one which is relevant here, is whether a respondent is required to comply with the terms of the court order pending the resolution of their application to challenge it. Now, Sandra Holdings doesn't say anything about that, because that wasn't the factual position in Sandra Holdings. That the Court of Appeal had before it findings of contempt, and the question they were asked to look at was whether or not those findings of contempt fell away if the freezing order fell away. What Sandra Holdings doesn't do is alter the position as set out in the authorities I've cited in my skeleton, that unless and until that order is set aside, the orders of the court have to be complied with. So in those circumstances, in my submission, we don't need to get into a lot of what my learned friend says about whether or not Sandra Holdings is correct, or whether we're correct to say that it's per incuriam. And I should say in that context, the submission that Sandra Holdings might be per incuriam is only relevant if the decision properly analysed suggests that parties do not have to comply with court orders unless and until set aside. As I've just submitted, that is not the question that Sandra Holdings was looking at, and it cannot follow that that was what the Court of Appeal decided. But what then in those circumstances is particularly concerning about the position that the first defendant is adopting at this hearing, and indeed in the run-up to this hearing, is the fact that, taken to its logical conclusion, the defendant's position would mean that he doesn't have to comply with any of the terms of the freezing order prior to the determination. So it's not, although the focus of this hearing is on the information orders, in theory, the logic of the first defendant's position is that he's free to dissipate his assets prior to Sandra Holdings as well. And we've had no sort of confirmation from the first defendant. And indeed, I don't know whether it might be worth asking my learned friend to confirm on instructions as to whether or not his client has complied with that, or whether he has even attempted to comply with it. But the difficulty from my client's position is that now that we know what the first defendant's position is as regards whether he needs to comply with the order, it logically follows that his position is that he's free to dissipate his assets. And that's of serious concern to my client in circumstances where, as Your Honour will recall from hearing the freezing order application in the first place, there was an express finding by the Dubai courts that the first defendant had dissipated his assets to attempt to frustrate the judgment against him, which led to Your Honour making the finding of real risk of dissipation in support of the freezing order. So in those circumstances, my submission is that the debate about the proper scope and interpretation of Sandra Holdings is something of a red herring, because the factual position here is very different, in the sense that we're asking here whether court orders should be obeyed in the interim. It's not a question of whether findings of contempt should be subsequently set aside once the freezing order is set aside. So that's simply the point I wanted to make on Sandra Holding. Your Honour already raised the point that we're in a very different factual scenario here, in circumstances where we have a final, binding and enforceable judgment of the Dubai court. And it may in fact be just worth briefly stating in relation to that we do not accept the first defendant's position that if the enforcement order is set aside, it must inexorably and inevitably follow that the freezing order is also set aside. And the reason we say that derives from something Your Honour raised earlier in response to my learned friend, which is that the DIFC court does have, to borrow the language from Sandra Holding, prima facie jurisdiction to recognise and enforce the Dubai judgment, whether or not the letter, the execution letter, relates to certain assets or not. There is a prima facie jurisdiction to recognise and enforce the Dubai judgment. And in those circumstances, even if the enforcement order is then set aside on the basis that the terms of the execution letter don't match up with the enforcement order, it does not follow that the freezing order must set aside, because the court still retains jurisdiction to make that order. Again, taken to its logical conclusion, the first defendant's position would be that a judgment creditor would not be entitled to apply for a freezing order immediately upon receipt of a judgment, a final and binding judgment of the Dubai courts, because they would need to wait for the execution letter process to have completed before they could even come to this court seeking freezing orders. And we say that that just simply isn't correct, not least because the test for the freezing order is good arguable case. So it's important, I think, to make that point clear, because that was a point relied on by my learned friend in relation to why he said no sanctions should be deployed at this hearing, because there is a risk that the enforcement order falls away. Well, our position is that even if the enforcement order falls away, it doesn't follow that the freezing order falls away. So I just wanted to make that point clear. Now, just two more points to deal with, I think, and this relates to the potential sanctions we've been discussing. The first is the sort of the debarring order Arab Monetary Fund point, and my learned friend says that you shouldn't make such an order, and that those orders should be made only in exceptional circumstances. Your Honour, I don't think we disagree, my learned friend and I, on the legal test to be applied, or whether or not exceptional circumstances need to be shown. But we say, whatever the test, this is plainly a case in which such an order should be made. And it might be worth just going back to page 2767 of the bundle, the Motorola credit decision, and the excerpt that my learned friend took you to. And in particular, the quote from Lord Justice Denning from Hadkinson and Hadkinson, where it states the starting point is that to refuse to hear the party, even a contemnor, is a strong thing, only to be justified by grave considerations of public policy. It is a step which court will only take when the contempt itself impedes the course of justice and there is no other effective means of securing compliance. Well, Your Honour, that in a nutshell is exactly what we say is the position here. Not only is the first defendant's contempt impeding the course of justice, because the very purpose of these proceedings is to enforce a judgment against assets which the first defendant is required to disclose. But at the same time, as Your Honour has already recognised, there is no other effective means of securing compliance. You can't make an order imprisoning him in order to force him to purge his contempt. He clearly has no regard to compliance with court orders. Your Honour made the point that in those circumstances, a fine is unlikely to encourage compliance with the terms of the disclosure order. So in those circumstances, the court may very well feel that this is the only method, the only effective means of securing the first defendant's compliance with its orders, because in the absence of that, there is effectively no power by which to force compliance in circumstances where the first defendant has historically shown a total disregard to compliance with not only this court's orders, but the orders of the onshore courts as well. So that's the first factor which I say justifies the debarring order. There are two or three others which you already have. The second is a point I've already made, which is the ease of compliance. The disclosure order should be very easy to comply with. And there's been no suggestion by the defendant that he would have any particular difficulty in listing his assets in the usual way. The third point you already have as well, which is that the contempt here is thwarting the very purpose of these proceedings and the purpose for which these proceedings have been brought, viz. The enforcement of the Dubai judgment. And the fourth factor and final factor I would rely on as a factor justifying a debarring order in these terms is simply what we would say is the egregious nature of the contempt and in particular the nature of the defendant's objection in circumstances where, as I have already said, the logic of the first defendant's position is that he's not required to comply with any of the terms of the freezing order. And that's an important point because my client has no comfort whatsoever in those circumstances that the first defendant is not dissipating his assets. If his position is, I do not need to comply with this order because I brought an application to set it aside, it must inexorably follow that he feels free to dissipate his assets as he has historically done. And that is particularly important in my submission when it comes to the court's consideration of what it can do to ensure that this litigant complies with this court's orders, and especially where there is a deliberate decision not to comply with those orders, and the extent to which the non-compliance exists is currently unclear and may indeed be thwarting the very purpose of these proceedings. Now, the only other point I wanted to raise in relation to this order is the submission my learned friend made that we essentially as claimant would suffer no prejudice if this order isn't made. There are a couple of points to make in relation to that. My learned friend obviously made the point that what we're seeking to do here is to enforce against shares in a company which holds assets which exceed the value of the judgment debt. And my learned friend said that that's the fastest method of execution available to us. Well, in fact, the fastest method of execution would be if his client would pay my client the judgment debt. And we've been forced to adopt this rather convoluted route of having to get a charging order over shares in a company that owns valuable assets. It would, if we could, we would explore the option of voting on those shares to sell part of those assets. But as far as we can discern, charging orders as opposed to equitable or legal charges don't grant the chargee with powers of voting rights under the shares. So in other words, we have no recourse other than to sell the shares in the company. And this is a situation, we say, which is of the first defendant's entirely the first defendant's own making. So the fact that this is the fastest route to execution on my learned friend's submission is not only not correct, but we say it's neither here nor there. In fact, we would go as far as to submit that it is in those circumstances, it is in the first defendant's interest to comply with the terms of the information order. If he has assets which are more readily available and can be executed against and which do not exceed the value of the judgment debt, it would obviously be in his interest to disclose those to avoid the need for a sale of the shares in his company at all. So that is also a point which we say militates in favour of sanctioning the first defendant at this stage. It may be that actually the sanction can cut across quite a lot of what is to come going forward procedurally. And in those circumstances, I wouldn't accept my learned friend's submission that holding it off to the subsequent hearing is more procedurally convenient. By contrast, having a list of the defendant's assets soon, i.e. within 7 days, as your Honour mentioned earlier, might help to cut through a lot of the substance of these proceedings if there are other assets against which we can enforce. So that is all I wanted to say about the debarring order. Now, just finally addressing what my learned friend said about paragraph 3 of our draft order and the order or the paragraph of the order requiring payment of the judgment debt. Your Honour, there are two points to make about this and why it is necessary. The first is, as my learned friend has already adverted to, which we don't dispute, the enforcement order itself doesn't have a penal notice attached to it. So breach of the enforcement order cannot itself amount to a contempt of cause. We accept that. What we are therefore aiming to do with this paragraph 3 is to have a court order that is fixed with a penal notice for the payment of the judgment debt, so that if the first defendant does not comply with that order, there is then the possibility of bringing proceedings for contempt in respect of that refusal to pay. The second point is one which I alluded to earlier, which is in relation to the time for compliance. Now, the point here is that if my client is not allowed to sell these shares over which it has a charging order for whatever reason, it needs to have effective recourse by other means to satisfy the judgment debt. And one way of doing that is a separate application for a writ of sequestration over those shares, which is only possible under the DIFC court rules if we have an order requiring the payment of the judgment debt within a specific period of time. So that is the reason that we have specified that the judgment debt should be paid within 7 days and that the order should include a penal notice, because if the first defendant then fails to comply, we are able to issue an application for a writ of sequestration in order to sequester the shares as an alternative to resolution through the charging order claim.
And the advantage of sequestration as opposed to charge?
It's effectively a plan B, I suppose, in circumstances where the charging order gets set aside.
But if you sequester the shares, can you then vote on the shares?
My understanding is that we can't. We would still need to go through the process of sale. It's just it gives us another route to get there in circumstances where the charging order is set aside. In other words, Your Honour, what we're attempting to do here is ensure that as many potential avenues to enforcement are open to my client as possible in circumstances where we've only been told of one asset. We've only discovered the existence of one set of assets. We weren't told about these properties by the first defendant. We are entitled to enforce against those. I've just received some instructions. It may be the case that if we do get a sequestration over the shares, we might be entitled to collect a dividend over those shares, possibly. So there may be additional practical advantages to that. But the other point that I was making is that having two routes of enforcement against those assets is crucial in circumstances where we have a judgment debtor who won't tell us what assets he's got, despite having been ordered to do so nearly 9 months ago by this court. So all we're trying to do is preserve as many routes as possible to enforcement against those assets in the face of a deliberate and very serious contempt of this court's orders. So I think, Your Honour, that probably concludes all I need to say. I might ask if I could have a similar indulgence of just a minute or two to check with my instructing solicitors to make sure there was nothing else, particularly in relation to the draft order that I needed to say. No, they have come back very quickly. Nothing further from me, Your Honour. Thank you.
Your Honour, I'm somewhat in your hands. I realise we've dealt with things slightly jumping about. There are two very short points which I think would take me no more than 2 minutes to cover off, just rising from what my learned friends just said. If you'll, yes. The first is just this suggestion that, well, we don't know what the logical extension is. It might well be that the freezing order is not being complied with. Your Honour, can take comfort that that's not the case, because the company registrar has confirmed that the portal is frozen and there's no way for those shares to be dissipated. So there's
what about other assets? Are they covered by the order?
I think that the terms of the order, I'll have to go back to deal with assets up to a value of X, and these exceed that. So, okay. So that's that point. The second really was to deal with this paragraph 23.3 of my learned friend Skeleton, which he addressed, which is, you know, if the enforcement order falls away, the worldwide freezing order doesn't necessarily. We don't agree or accept that proposition. The arguments.
An argument for another day, isn't it?
Yes, it is. It's a question of jurisdiction, and the point is, if the scope of the order doesn't include enforcement over the shares, what JAL requires is that you have some subject matter of execution for the court to have jurisdiction. And in this case, if it's not the shares, then it's nothing. And so the effective standing holdings, the court wouldn't have jurisdiction to make the freezing order either. So it's an all or nothing in our submission. Either they all fall away or none of them do is the likely outcome either way of the substantive hearing. That's all I wanted to flag. Hopefully I've dealt with that in, I think, half the time I suggested.
Yes, well, you might get into arguments about prima facie jurisdiction and ordinary jurisdiction then, but there we are.
You're on it. If I could just say one very brief point in relation to that last point my learned friend made, that in my submission, that is a rather extraordinary submission to make, that the first defendant can refuse to give any information as to the existence of his assets under the terms of a freezing order, and then rely on that failure to say, oh, there are no assets against which you can enforce, therefore your freezing order must fall. I mean, that's, you have the point, but it's an argument for another day.
Yes, very good. All right. Well, I think the right thing for me to do is to give a ruling explaining what I'm going to do before making the order I'm going to make. In this matter, the claimant applies for an order for committal for contempt of court on the basis that the defendants have failed to comply with the worldwide freezing order, and in particular to give the disclosure of assets that was ordered by the court, first within a period of 7 days on the basis of information, and then within a further period by way of affidavit. The timetable of this matter bears repetition. It was as long ago as the 31st of October 2018 that the Onshore Court of Appeal in Dubai gave judgment against the first defendant in the sum of some $15.5 million US. That judgment became finally enforceable when the Court of Cassation in the onshore Dubai dismissed an appeal on the 24th of February 2019. For various complicated reasons, it was not until the 1st of February 2023 that an application for an interim charging order was made in this jurisdiction, together with an application for a worldwide freezing injunction. That was based on an execution letter from onshore Dubai dated the 31st of January 2023. On the 3rd of February, the court made the orders sought on an ex parte basis for recognition and enforcement of the onshore Dubai judgment, for a worldwide freezing order, and for an interim charging order over shares held by the first defendant and the second defendant. On the return date, the court continued the worldwide freezing order and made a final charging order over the first defendant's shares in the second defendant, in the absence of the first defendant, who says he was in prison at the relevant time. In July 2023, a Part 8 claim was instituted by the claimant for the sale of the first defendant's shares in the second defendant pursuant to the final charging order. On the 20th of September of this year, the first defendant applied to set aside the enforcement order, the worldwide freezing order, and the charging order. And in due course, later, a case management timetable was agreed for the hearing of those matters, with the hearing now fixed for a date in some 3 weeks' time. On the 27th of October of this year, the claimant brought its application for contempt, and the first defendant was duly served, first and second defendant were duly served in accordance with court orders in circumstances where, despite having solicitors instructed, the process of services made as difficult as possible by the defendant. The court consequently ordered alternative service, which has not been challenged. In accordance with the court's orders, the reply evidence of the defendant in relation to the application for contempt was due on the 8th of November. There have been a series of applications made by the first defendant, mostly dealt with by the court on paper, in order to postpone the hearing of the contempt application from its listed date today. None of those succeeded because I could see no basis upon which such a stay should be granted, particularly in the absence of any information as to what evidence might be required to deal with the application for contempt, and the absence of any express defence to the application for contempt. That remains the position as at today. The breach of the disclosure obligations under the worldwide freezing order is undoubted. The breach does not depend on whether or not the order was validly or correctly made, with or without jurisdiction. That remains a fundamental principle of the common law, as is made plain by various passages in the textbook by Stephen G., which recites various authorities to the same effect. I have been directed to various passages in the Court of Appeal decision in Sandra Holdings, and in particular paragraphs 108 to 112, as to how matters of this kind should be dealt with. I do not consider that I'm bound by those passages to conclude that it is open to a defendant to ignore the terms of a court order simply on the basis that he wishes to challenge it, whether on the grounds of jurisdiction or any other ground. I do not consider that's what the Court of Appeal is saying at all, or that it had this situation in mind. The effect of what the first defendant has throughout sought to do is to disregard the orders of the onshore Dubai court and now the orders of the DIFC court, and seeks impunity for doing so on the basis of a challenge that it proposes to mount to the enforcement jurisdiction of this court. The fundamental position must be that unless and until a court order is set aside, it has to be obeyed. The defendants are therefore in contempt in not serving the affidavit evidence disclosing assets, which was originally due on the 20th of February of this year. Since that time, the first defendant has been represented by a series of different lawyers, 3 or 4 firms, I think, in all, with whom there has been correspondence, making it plain that the first defendant is in contempt of court in failing to obey the relevant orders. As pointed out by counsel for the claimant, if the first defendant feels free to disobey a court order in relation to disclosure, there is every reason to believe that he will feel free to disobey a court order in other respects. The fact that the shares appear to have been secured according to the Registrar of Companies is not due to his own actions. In circumstances where he apparently feels free to do exactly what he wants regardless. The iniquity in what the first defendant has done so far is that it impedes the course of justice. If, as he argues, for the purpose of setting aside the enforcement proceedings, the Dubai execution letter does not allow enforcement against the shares, then the other assets which he has are of critical importance. The one thing that the claimant then wishes to know in order to enforce the onshore Dubai judgment and now the DIFC enforcement proceedings is what assets there are to enforce against. This is a very different situation from that which obtained in Sandra Holdings. The principles that are set out in the Motorola and Arab Monetary Fund case, which are referred to in the Sandra Holdings Court of Appeal decision, focus upon what the interests of justice require in the context of dealing with a contemnor or alleged contemnor. There is the key question is what the interests of justice require in such circumstances, and the court has a discretion as to whether or not to hear a contemnor until his contempt is purged. The courts have said that it is an exceptional circumstances. It is an exceptional circumstances where the court will not hear from a party in the representations it wishes to make, but there nonetheless has to be some restriction where a contemnor is simply defying the court's orders and refusing to pay any attention to them at all. An opportunity is often given for the contempt to be purged so that the contemnor can then be heard. There is, as is plain from the course of action adopted by the first instance judge in Sandra Holdings, a difference between an alleged contemnor applying to set aside an order on the basis that the court had no jurisdiction at all to make the order in question, a lack of prima facie jurisdiction, to use the Court of Appeal's expression, and other circumstances where the contemnor seeks to set it aside for reasons which do not go directly to the court's jurisdiction, prima facie jurisdiction, but to the application of that jurisdiction. As I've said here, the defendant's conduct directly impedes the course of justice, and as put by Lord Denning in one of the earlier cases, the question arises as to what effective means there may otherwise be of ensuring compliance if the contemnor is not to be prevented from addressing the court. It appears to me here that this defendant has no intention of complying with court orders unless he absolutely is compelled to do so. Whether talking about orders in the onshore Dubai or in the DIFC, he has already been found in onshore Dubai to have moved assets in order to frustrate the judgment being executed against him. In these circumstances, it seems to me that the correct order that I should make today, where the challenge to the enforcement order is due to be heard in 3 weeks, is to make a declaration that the first defendant is in contempt of court, and that I do. There is no defence to the committal complaint. None has been offered as a reason for not complying with the order to give disclosure, and there can therefore be nothing further that could be said. Mr. Doherty, who appeared for the defendant, said he had no instructions as to what the defence was, and he had equally nothing to say about what evidence could possibly be relevant to adduce in that context. His submission that matters should be stayed today and everything should be put off until after the enforcement application had been dealt with is therefore refused because it would achieve nothing. It is, however, obviously relevant at the end of the day to the sanctions that might be imposed, whether or not the order should in the first place have been made. It is necessary for the court to mark the fact that there is contempt regardless of whether at the end of the day the earlier order for enforcement is set aside. It is also important that the court should do all that it can to ensure that its orders are complied with. In these circumstances, the right course appears to me to give the defendant, the first defendant, a further 7 days in which to purge his contempt by producing the affidavits relating to his assets, which was originally due on the 20th of February 2023. The question which then arises is what sanction should be applied if there is a failure to purge the contempt within that period. It seems to me that the court ought to take the view that it would be unlikely to hear the defendant in relation to anything other than what is described by the Court of Appeal as a point which goes to the prima facie jurisdiction of this court. And that is the order that I make. The court will, absent special permission being given, not hear the first defendant on anything other than a point as to prima facie jurisdiction in relation to the enforcement application, unless that contempt is purged by the production of the affidavit in question. Turning then to one or two other matters which arise out of the draft form of order that was currently sought. It is clear from what I have said that the court is not going to impose any sanctions today other than that which I've referred to in the context of purging the contempt and not hearing on other points at the hearing in 3 weeks' time. It also follows that I am not going to make an order of the kind which is being sought in paragraph 3 of the draft order put before the court, which required the first defendant to comply with the enforcement order and satisfy the judgment date within 7 days of today on further penalty of contempt. It seems to me that if there is to be an order which has a time limit, which would enable sequestration of assets as opposed to simply charging the shares, that is a matter which should be dealt with appropriately at the time of the enforcement application being considered and determined. Is there anything else that I need to cover at this point?
Sorry, you're. I don't know if my learned friend was attempting to say anything. I was just the only point I was going to raise was that Your Honour's judgment related principally to the first defendant. We have our application is also against the second defendant, which is not present today. Now there are additional principles which apply to making findings of contempt against parties who decline to attend committal hearings. Principally the fact that they've been given sufficient notice and have elected essentially not to participate. The claimant's position is that given that the second defendant is wholly owned by the first defendant and that he's one of the two directors, that there's no reason why the second defendant should not have been present today. And indeed, we don't entirely understand why the first defendant and second defendant aren't jointly represented. But nevertheless, in those circumstances, I think we would ask that the orders you have made do extend to the second defendant as well, in circumstances where the contempts of the first defendant are exactly the same. They apply mutatis mutandis to the second defendant, which had more than adequate opportunity to attend today's hearing, but declined to do so.
The Charles Russell's speech lists are on record for both the first and second defendant?
I think just the first defendant, but my learned friend can confirm.
What's the position on that, Mr. Doherty?
Yes, bear with me just 1 second, Your Honour. I'm just confirming the position. Yes, so we act for D1.
And D2?
D1 only.
Only D1. D2 is unrepresented, is it?
Yes.
All right. Well, I'll add this then. In the situation where the second defendant is not represented, but has chosen not to appear before this court after being properly served with the contempt application, the orders that I have made vis-a-vis the first defendant apply mutatis mutandis to the second defendant, which is 100% owned by the first defendant and therefore can be said to be under his control. In those circumstances, there can be no good reason for their failure to either comply with the orders in the first place or to appear today, and they are therefore subject to the self-same orders as the first defendant. All right. Can you draw up the order, please, Mr. Anderson, and agree that with Mr. Doherty and then send it for approval by the court?
Your Honour, I can certainly do so. The only other remaining question, I think, is the question of costs of today.
Yes. Well, must follow the event, mustn't they, Mr. Doherty?
Your Honour, respectfully, for a number of reasons, we say that the better order to make now at this juncture would be cost reserved. Your Honour has had the pleasure of dealing with me in other cases where it has been relevant for the court to take a rounded view when it comes to costs. In 3 weeks' time, we're going to have a hearing which deals with the set-aside applications. I think it was only a couple of days ago that the Court of Appeal handed down its own cost decision in Sandra Holdings, awarding 80% of costs here and below. And really, it's the sequencing issue that I addressed, Your Honour, on, which is trying to avoid unnecessary protective appeals where there are pragmatic ways that one can cut through. I don't think that there's necessarily any dispute that if, following the applications Your Honour is subsequently going to hear, that the claimant is right about everything and the contempt order doesn't fall away, that it will be making its application for costs. We say that the better way to deal with that would be to deal with it in 3 weeks' time when you have that rounded view and you know what the outcome of the hearings in total are, in order to avoid this situation where it might fall away. There are issues about the order being properly made, but ultimately the decision in Sandra Holdings is that on appeal, if an order was made that shouldn't have been, costs here and below end up being reversed and it ends up being a bit more of a procedural mess. We're only dealing with deferring the question a matter of 3 weeks. So in my submission, that would be the more appropriate course.
Well, I'm against you on that, Mr. Doherty. Your client has done his best to postpone the evil day of dealing with contempt, which is plain and obvious and to which he has no defence. In those circumstances, the right order must be that your client should bear the costs.
Your Honour,
schedule somewhere?
Yes, it's in section T of the bundle, tab 1. And while you're pulling that up, Your Honour, we would be asking for those costs to be immediately assessed on the indemnity basis as well, given the defendant's conduct as found in your judgment in relation to flagrant and deliberate breaching of court orders, which takes this case outside the usual, the run of the norm. The schedule is at page 2877 to 877, and the total number we seek is on the next page, 142,450.47. What worth pointing out, my lord, before Mr. Doherty obviously addressed you on that, is that the defendants did also file a cost schedule as well, and their grand total of costs was 223,000 odd. So notwithstanding that we were the applicant, our costs have come in at nearly 100,000 dirhams lower than the other sides.
Yes, well, they had a more difficult row to hoe, it could be said. Yes, all right. Mr. Doherty, what do you want to say?
Yes, Your Honour. I mean, you've obviously seen the broader procedural background and what's gone into the defendant's own costs there. I think you've made the point already on that. This is the claimant's application, which it said was a light application. We would say that it's stepping back, the grand total being incurred. The court could take the view that those aren't reasonably incurred and there should be some discount to that, given the scope of work that the claimant had to carry out. I mean, in terms of particular items, 3 fee earners with rates between 2,000 and 3,300 attending the hearing might be viewed as being unreasonable, when it's unclear why one would need 3 separate fee earners attending this sort of hearing. There's quite a significant amount of time in attendances on opponents, which we would say also appears to be somewhat steep in that context.
What, when you raised all these objections, there's been a...
Well, yes, but Your Honour might recall that the initial response to that was that the claim solicitors gave it pretty curt responses to it. It wasn't War and Peace.
They still had to read 6-page letters from Charles Russell Speechless, as indeed I had to. Yes, go on.
Yes, sorry, bear with me. Let me pull up the cost schedule again. And yes, I suppose there was point of the disparity in work done on documents, I think, is some 26 hours as compared to 22 in our schedule. So those are the specific costs. I mean, obviously, you're going to be pretty broad brush about this, but when you step back, we say that it would be appropriate to make a deduction from that total.
Well, I don't think there's anything in the specific points raised except perhaps the idea that it was necessary for all 3 members to appear on the at the hearing, to attend the hearing. But having said that, if they put work into it, no doubt they were very interested to know what the outcome was going to be and to listen to the debate. There will inevitably be a small discount because that's what life is like, but I don't see any basis for anything major in the context of what I consider is an appropriate case for indemnity costs, as one being outside the norm in the case of a party being in contempt, and raising every possible argument as to why matters should be postponed and dealt with in a different way. So in the circumstances, I'm going to order the sum of 130,000 dirhams as the grand total by way of summary assessment. All right.
I'm grateful. We will draw up that order. Can I just clarify that is against both first and second and payable within 14 days as well?
Make it 21.
21. I'm grateful. Nothing further from me then, Your Honour. I'm grateful. Thank you.
All right. Anything further, Mr. Doherty?
No, thank you, Your Honour.
Very good. Well, I'll see you all in a few weeks' time then, by the sound of it.
Grateful, Your Honour. Thank you.
If you would just like to sign out, then I'll have a quick word with the associate. Thank you very much.
I'm grateful. Thank you, Your Honour. Good morning.